Good evening. Thank you so much for making time to join us tonight for this special edition of the eligibility of Edgar Lungu to contest the 2021 elections and the future elections. We've been counting down to Tuesday, which is today, the 10th of December. And obviously, the Court did deliver a landmark judgment on whether Edgar Lungu was eligible to contest the 2021 elections and whether he is eligible to contest the future elections. And the decision has been very clear by the Constitutional Court that Edgar Lungu does not qualify to contest the future elections. Also, they did touch on the elections of 2021 and why they allowed Edgar Lungu to contest that particular election. And that's why we're here tonight to discuss and analyze the judgment that was delivered earlier on today by the Constitutional Court judges. Thanks so much for joining us once again. My name is Andrew Mwansa.
And my name is Darius, Choonya. Does this judgment put an end to any other petition which will challenge the eligibility of former Republican President Edgar Lungu to contest the 2021 as well as a future election? Well, only time will tell. But tonight on the program, like earlier alluded to by Andrew, we will look at a judgment that has been delivered by 7 Constitutional Court judges, and they've actually all approved this judgment, saying that the former Republican President Edgar Lungu is not eligible to contest any future election, but was eligible to contest the 2021 election.
And that's the reason for why we're joined in by a panel of legal experts to explain to us how Edgar Lungu was eligible to contest the 2021 elections, but isn't eligible to contest the 2026 elections. Tonight we're privileged to be joined in by Dr. Obrien Kaaba, constitutional lawyer. Thank you so much, Doc, for making time to be with us tonight.
Thank you for having me.
We're also privileged to be joined in by constitutional lawyer in Mehluli, Malisa, who also has been with us from the time that we started building up to this very case. Counsel, thank you so much for making time to join us tonight for this very special program.
Thank you for inviting me again.
Obviously, it goes without saying that others happy, others not happy, others consider this as a win, others not considering this as a win. One of those people that don't consider this as a win and see this as a dark cloud on their political party is the Patriotic Front, the former ruling party. And that's the reason for why the faction president of the Patriotic Front, Gavin Lwinda, had this to say earlier on today.
President Edgar Lungu, when he returned to active politics on the 28th of October 2023, he said he was coming back, not because he was seeking presidency again. He said he was coming back because he wanted to restore democracy. He wanted to partner with others to restore democracy. These people here, all of us here, without exception, and our partners in other political parties are the ones who went to him and said, President Edgar Lungu, we want you on the ballot paper. So it's not a question of us not having people who could succeed him, no. And you know, when President Edgar Lungu stands in 2026, he will not come again in 2031. Do you think the Tonsa Alliance would like to be in power only for 5 years? No. There is somebody else. There are others in the party, in the alliance, who can succeed him and who shall succeed him. But for 2026, he is our man. And no one, what we are refusing in Choonya is for anyone outside ourselves to determine who our candidate is. Please give us the right. Sure, we just say, oh, because the Concord today has said this, therefore we agree. No, we have not agreed. We are not in agreement with this judgment. We are not in agreement. Finished. We are still standing firm that ours is eligible. And there are many options, madam, isn't it? Many options, including going back to the same court. But you never know, we could even use our own Mingala maybe we'll go to local court. Huh? We might go to local court.
Assertions that President Hakainde Hichilema, State House, or any other government functionary has had a hand in this judgment have got no merit or basis whatsoever. They are and must be treated as such to be mere political rhetoric and all well-meaning Zambians and beyond should dismiss such kind of assertions with the deserving contempt. Clearly today, even those who were arguing that former President Lungu was eligible, them being lawyers, if you look them in the eyes, you only get one reaction, that the court has done justice, and not just doing justice, but that justice has been seen to be done. Therefore,
reaction from PF Vice President in Luwinda, but also followed by a reaction coming through from the Chief Government Spokesperson in Cornelius Mweta, who also happens to be Minister responsible for information and media. But also today was a very special day because the media had an opportunity to broadcast this live within the court premises, and for the avoidance of doubt and how the court judgment was delivered. This is what Deputy President of the Constitutional Court pronounced in this judgment that the country was awaiting.
6. If the Vice President assumes the office of President in accordance with Clause 5A, or a person is elected to the office of President as a result of an election held in accordance with Clause 5B, the Vice President or the President-elect shall serve for an expired term of office and be deemed for the purpose of Clause 3A to have served a full term as President if at the date on which the President assumed office at least 3 years remain before the date of the next general election, or B, not to have served a term of office as President if at the date on which the President assumed office less than 3 years remain before the date of the next general election. Article 1063 of the Constitution, when read with Article 106, Sub-Article 6 of the Constitution, provides that a person may or may not be deemed to have served a full inherited term. In common parlance, deeming relates to viewing or perceiving something in a contrived way. More formally, Black's Law Dictionary, 9th edition, gives as a main definition of the verb deem to treat something as if one, it were really something else, and two, it had qualities that it does not have. Hence, deeming allows an inherited term to count or not, depending on the length of time served. In our considered view, the contradiction between the two sub-clauses arises if the objective of the deeming is to enable the person who served an inherited term to contest more than one future presidential election, as it would create an exception. We have considered the issue on the basis of well-settled principle that constitutional provisions should be interpreted in a manner that harmonizes them. An exception to the clear prohibition in Article 106, Sub-Article 3, would have to be explicit and cannot be imputed from the language of deeming, especially in the face of the people's expressed commitment to a maximum of 2 terms. Hence, the deeming can only be consequential as opposed to empowering or permissive. We are of the firm view that the words "be deemed for the purpose" are intended to settle post-presidential questions about the legal status and the entitlements of a former president, as opposed to providing for a person's eligibility to return to the presidency beyond the mandated 2 terms. On a holistic reading of Articles 1, 5, 8, 9, 118, and 267 of the Constitution, with Article 106 of the Constitution, we find that Article 106, Subarticle 6 of the Constitution, does not create a 3rd term. Final orders. Our combined interpretation, therefore, of Sections 2 and 7 of the Act and the repealed Article 35 of the Constitution is that the first respondent's term of office, that ran from 25th January 2015 to 13th September 2016, constituted a term of office. The first respondent's term, which ran from 13th September 2016 to August 2021, constituted his 2nd term. The first respondent, Mr. Edgar Chagwa, has therefore been twice elected and has twice held office. Article 106(3) of the Constitution makes the first respondent ineligible to participate in any future elections as a presidential candidate.
Deputy President of the Constitutional Court there rendering a judgment, a landmark judgment, I should make mention. But on a lighter note, councils, I think what now comes out as a buzzword, from this Constitutional Court hearing, very interesting terms: res judicata, incurium, and factus official. Perhaps maybe help us understand what those terms mean, Councillor Malisa, before we can get into discussing some of these technicalities.
I thought you were going to ask the lecturer.
No, you're the practitioner.
Political terms. Okay, so the what you say, res judicata?
Yes. What does that mean?
Okay, res judicata is a principle that the courts apply. That what can I say? The other name is issue estoppel, where if an issue has been decided by the courts substantively, then it becomes a bar for future litigation. You can't litigate on the same matter. That is what res judicata means. So it's like a doctrine that the courts use. Say the matter is res judicata, there should be finality in litigation. So if I sue him for something today, the courts decide. We go to court, we litigate, and then the courts give a judgment. I can't then come again the following week and say, I'm suing you again for the same thing. Then the issue of res judicata comes in. And if you go to court, the court says, no, this issue is res judicata. We've already decided on it. So it means already decided. Then you mentioned what?
Factus official.
Factus official. It simply means that it has done its job. So when they say the court is factus official, it means the court has finished its job. So when the court hears the matter and gives a judgment, and it becomes factus official, it means our job is done.
It's done.
Our function is done.
It's done.
Yes. And then what? Pay in curia. Okay, so it's pay in curiam is another principle of law that relates to, it's an exception to the doctrine of stare decisis.
Yeah.
That simply entails that a decision by a court is made maybe without particular reference, or in omission, or in ignorance of some law and some fact, which if it had known about it, would have come up with a different decision. So a decision will be said, it will be pay in curiam. It's like we overlooked certain things were not taken into account. So which means that if the court say this decision is pay in curiam, it means that they will refuse to follow the precedent set in the earlier case. Yes, so it means they will depart from that precedent, or it means it's no longer binding, even on the lower courts. If you know that the pinnacle courts, their decisions are binding on lower courts.
Yeah.
So if a decision is per incuriam, it means it's no longer binding.
That's interesting. At least our people have been helped.
Yes, I mean, we have also been schooled here,
Yes.
Andrew. We are listening to the judgment just in the morning today, and these are some of the words that, you know,
consistently being used.
came out from Deputy Concourt President Anodzi Shilim.
Let's begin off with you, Dr. Brian Kaaba. I would like to get your general reaction to this landmark decision that has been made. The Constitutional Court has vacated its earlier decision in the Daniel Pule case and in the Legal Resource Foundation case. Earlier on, I think during the course of the week, we had you, Councillor Malisa, and you say this is indeed something that the legal fraternity is looking to. The judgment that the Constitutional Court will make is what the legal fraternity is looking to, whether they're going to maintain their decision or they're going to vacate. Let me begin off with you, Dr. Obrien Kaaba. Generally, what do you make of this judgment?
Yeah, thanks, and thanks again for inviting me to this discussion. So this is a massive decision, considering the political context in which we are, as it related to the candidature of the former President Edgar Lungu, as to whether he qualifies to run another term. So it has naturally two implications, legal and political. So on the political side, the decision basically means that the former ruling party has to find another candidate. So I think in the current context, as a result of that, the political debate is likely to come out strongly than the legal analysis of the case. From the legal perspective, the issue was to whether the former president qualified to stand based on the interpretation of the current Article 106 and the repealed Article 35. So both articles deal with the situation where a sitting president, for some reason, leaves office mid-term, and in this case it was through death. So as a result of death, as we all know, President Sata died in office. And following his death, there was a transition process, and President Lungu assumed office following an election. So he assumed office on the basis of what the law was then, which was Article 35. Under that clause, you were deemed, I think that is the term the court used, deemed to have served a full term, regardless of how long you were in the office. So he was in office for about a year, and so that, according to the court, is a full term. And the provision then did not make a distinction in terms of the durability of someone's term in office. But in 2016, there was a change to the Constitution, and so Article 106 entertains two approaches to how someone should be treated when they come into office in that manner. So the first one is when the person is in office less than 3 years, and according to the clause, that is not considered to be a full term. So the person then would subsequently be entitled to run for office for 2 more terms. And then if a person was in office for 3 or more years, then that is deemed to be a full term, and the person would be disqualified to seek a third term. So in this case, the issue was as to whether the appropriate clause to apply was the repealed Article 35 or the current Article 106. So the court reasoned that since President Lungu took office under the pre-2016 Constitution, the appropriate clause was Article 35, which basically meant that even if he served just even a week or a day, then that is a full term and therefore was not qualified. And then they also looked at their own past decisions, and they held that those decisions were wrong on account that they did not take into account the transition clauses, which effectively meant that the term President Lungu was serving is the one which is defined under Article 35, which is repealed, yes.
Councillor Malisa, do you find the arguments, the interpretations in this judgment to be satisfactory according to you?
Yes. That's my simple answer. Yes. If you remember when I was here on it was Sunday when I was at State Council Sakulas Court, yeah, I talked about what my lecturer has just said on whether they are going to apply it retrospectively or not. And I made the argument that according to me, I'm not the court, Article 106, sub-article 6, or let me just say the whole Article 106 was not in existence at the time President Edgar Lungu was elected in 2015. So the question would be, why would the court apply a provision which had not been enacted at the time he was taking office? So then that would mean that is retroactive application of the law. And the Supreme Court and almost all the courts in this country refuse to apply the code retroactively. Actually, Section 10 of the Interpretation and General Provisions Act, which is Chapter 2 of the Laws of Zambia, says that the law does not apply retrospectively, but it applies forward. So then, in this case now, the question was whether this Article 106 should be applied retroactively to the first term to President Edgar Lungu. And using the logic that the court pronounced today, they said that because in 2015, the applicable law which was there was Article 35. So then Article 35 was saved by Section 7 of Cap 1, right, which is so there's Constitution Amendment Act number 1, which is the transitional provision, and Act number 2, which is the Constitution itself. So Act number 1 is the one which saved this. It says, Act number 7 simply says the person who was president before the amendment remains president for the remainder of the term. So according to the court then, by virtue of Section 7, it means that Article 7 was also, Article 35 was also saved because it is the one which was applicable at the time when former President Edgar Lungu was elected. So do I agree with the reasoning of the court? Yes,
you do. Before Darius comes in, Dr. Kaaba, I think the argument that has come out of this judgment is the fact that the court had no jurisdiction to vacate its own decision. Obviously, in rendering the judgment, they made reference to different jurisdictions: Kenya, South Africa, the United States, and all that. But maybe make us understand what provisions of the law, empowered the Constitutional Court to vacate from their earlier decision. Do we have provisions of the law that does empower the Constitutional Court to vacate from their decision?
Yeah, thanks. So, as I understand the judgment, I think they relied on what they called the inherent jurisdiction of the court to vacate previous decisions, and they cited several authorities, I think from 5 or 6 jurisdictions. But for me, I think it's not, the issue is not pinpointing the exact provision. I think it's the issue of interrogating the general purpose of adjudication. And precedent, I think, which is being used by some people here, that they shouldn't vacate a previous precedent, is not an adequate argument, because adjudication has several goals. So certainty is just one of them. So there are some times when fairness should override certainty. There are also times when correctness should override certainty. So it is up to the litigants to convince a court as to what goal of litigation should override in a specific case. And in this case, the court seems to have been convinced that they should go for correctness and correct interpretation of the Constitution and supporting laws in this case. And my colleague has indicated that that is the correct interpretation. So to the extent that their reasoning is grounded, then they cannot be faulted simply because they have moved away from a precedent they had set. And in my view, I think this potentially suggests that we could move away from mechanical application of precedents. So that could be good if it is sustained and there is
Doesn't that create
justification.
instability within the legal provision, where you can make reference to precedents because precedent can be changed?
I think when you read the judgment, the court said there must be compelling reasons. So you must show that there are exceptional circumstances that have to move the court. So it shouldn't be just someone waking up and saying, I feel the court should move in this direction. So you must move the court with compelling reasons so that the court agrees with you.
Counsel, just make us understand. The concern that has come out there, especially from those that don't agree with the interpretation that has been made by the Constitutional Court. I mean, earlier on we heard what the Patriotic Front faction Vice President, Given Winda, said. 3 times the Constitutional Court ruled that the former president was eligible to contest the 2021 election, and consequently also allowing him to contest even a future election because he lost the 2021 general election. Why now that we have, this interpretation which you have said is correct? Could it be that there could be some, external forces in the previous judgments that were delivered? This is a question that many people, have asked, because why should it be on 3 occasions that the same, judgment is rendered by the Constitutional Court, and only now that we are hearing that it did not, correctly interpret the provisions of the Constitution?
Okay. I cannot speak to external forces because I don't know about them. Right? But I'm going to speak about, to pick on from where Dr. Kaaba said. The issue of courts changing precedent did not start today. It's not new. Even in this country, it has happened. In as much as the Constitutional Court took us around the world, from the US, Kenya, Zimbabwe, wherever, South Africa, in this country we have precedent where the Supreme Court has abandoned its earlier decision. There are a number of cases, I was writing them down here: March Corporation Limited and Development Bank of Zambia. There's also Patton versus Attorney General, this is 1968. Kasote versus the People, 1977. So it has been happening. A more recent phenomenon is the famous case from the United States where the Supreme Court in the US departed, it changed the precedent in Roe versus Wade after 50 years. So which means in those 50 years they kept on repeating, and then 50 years later they decided we want to change.
But there's provision within the apex of that court that empowers them to vacate, isn't it?
In the US?
In the US, even in our Supreme Court.
Yes. In the Supreme Court. But if you heard what Justice Shilini said, he said that the Constitution, there is no express provision that provides for the Constitutional Court, one, to say its decisions are binding on itself. It's not there. and that it can depart from its decision. He said that it was not there. In the judgment, it's there. They said it's not there. So what Dr. Kaaba said is that the inherent jurisdiction of the court. And when he went to other jurisdictions, he said, I think he said in the Supreme Court of Zimbabwe, that provision is not there. Even in the Constitutional Court for South Africa, that provision is not there. But the decisions from that court impute that this court, because it is an apex court, it creates precedent, then equally it has the power to change that precedent. So what he said is that that power to change precedent should be exercised in circumstances. It shouldn't be exercised willy-nilly, right? It should be exercised where there is a need either to do justice or there was a wrong decision.
You earlier mentioned on Sunday that there must be very much compelling evidence beyond reasonable doubt that the Concord will be pushed to, vacate their position.
I didn't say beyond reasonable.
And also in addition, Andrew.
I said there should be compelling reasons.
That was a bit of an exaggeration.
Yeah,
but
there should be compelling reasons.
Compelling reasons.
Yeah.
You feel those arguments that were presented by Chizombe were really compelling for this decision to be vacated?
And maybe before the response to that question, Andrew, shouldn't there be a finality to matters that are brought before a court, especially the Constitutional Court, which is the final court to interpret constitutional related matters? Dr. Kaaba.
Yeah, there should be finality, and if you read the judgment, I think the judges try to navigate that issue carefully. So what they indicate in the judgment is that they are not reviewing the precedents they set, but they are simply vacating those decisions. So basically, they are not changing anything in those decisions, but at the same time, they're abandoning them. So, so a bit confusing, but I think that's how they navigated it. So there should be finality. But at the same time, I think finality is not the only goal of litigation and the judicial system. So there are other interests like fairness, correctness of the decision. So depending on circumstances, if you move the court that it shouldn't stay with the decision which is patently incorrect, and if they agree with you, then they could, and in this case they did. They decided to agree with the person who moved to the court. Yes.
Councillor Malisa, I think also what is confusing now is the fact that Edgar Lungu was eligible to contest in 2021, but is ineligible to contest in 2026. How?
Go ahead.
How?
Because the court said so.
Make us understand how they arrived at that decision.
Okay. The same court is the one which said he was eligible in 2021.
Yes.
If you remember correctly, there was a challenge in 2021, which was launched by Sishua Chapter 1 Foundation. What's the other one?
Legal
Resources Foundation. Yes, that case. They went to court and advanced arguments that former President Lungu is not eligible. And the court made a decision and said, no, he is eligible. So a decision of a court is valid. It's binding on everyone until the court says it is no longer valid, or until the court overturns that decision. So on the basis of the decision of the court in the Legal Resources Foundation case, that's how former President Edgar Lungu found himself on the ballot. Now, the same court which said he was eligible has come now and said, oh, no, that decision we made in 2021, we can no longer stand by it. We can no longer defend it because we made it in the absence of reference to other parts of the law. It's the same court.
So they acknowledge that they made a mistake.
In short, yes. That's what they're saying. They're saying they made a
what
wrong
potentially
decision
would have happened
and
if
they want to correct it. Or it can happen, like I said, this is not the first time, right? I'll give you just a line from the case of Abel Banda versus the People, which is 1986, Zambia Law Report 105. The Supreme Court said, the problem before us, therefore, is that we have made case law which we have now realized is indefensible. Right? Right. So they're saying that they acknowledge that they have made case law in the past, but now they can no longer defend it. It's indefensible according to them, according to the Supreme Court. And then now, it will force them now to relook at their decision. So I should think that it is the same situation here. If you look at the tenure of the judgment and how Deputy Judge President Shirimi pronounced it, he kept on saying that we have the power to correct ourselves if we made a previous wrong decision. So the feeling we get from this whole judgment is that the Constitutional Court came to the realization that in Dan Pule and Legal Resources Foundation case, they had made a decision. Yes, it's their decision. They owned it. They said it's our decision. But they realized that their decision somehow came short, and then they decided now to leave it, because they found that they can no longer defend it. Because one of the parties in this case, who is the respondent, actually told them to say, hey, you decided like this. But for them to say, we are moving away from our decision, it means that similar to the Supreme Court in that case, they could no longer stand by their decision. They could no longer defend it.
Let's talk about, maybe the implications. If the Constitutional Court would have said that the former President Edgar Lungu was not even eligible also to contest the 2021 general election, what would have happened politically, Dr. Kaaba?
Yeah, thanks. I'll start from where he ended, actually. So actually, on the issue of his eligibility in 2021, I think the court was a bit more careful in the way it was using words. So it actually didn't say he was eligible. It said at the time of holding the 2021 election, the Legal Resources Foundation case was binding and therefore enabling the respondent to stand for election. So it didn't say he was eligible, but it says that there was a case which was binding, and as a result, it was on the authority of that case he stood. But then that is where I have a bit of a problem with the decision, because I think it's inadequately rationalized by the court. Because if in 2021, these provisions that rely on to determine that he's not eligible now were in place, it means even at that time he didn't qualify to run. That is my humble view. And as a result, the court should have gone beyond what it just said to rationalize why then the position of 2021 should not be disrupted. And in my view, I think this is where the expertise of the court should have helped the people in developing appropriate remedies. I think in constitutional law, the remedies are available. One of them they could have explored is the doctrine of prospective annulment. So you state the law as it should be, that he was ineligible, but then you save the country from the consequences of the voidance of what should have been in order to maintain the Constitution. I think that's the better
Don't you think then this leaves room for litigation again? Someone can go to the Constitutional Court and say, because you interpreted this in this manner, and so I'm bringing these matters before the court.
No, here what I stated is what I thought should have been the case, not what the court said itself. So in terms of what the court has said, I think
what I'm getting is that, according to you, in your humble and respectful view, that interpretation is not very satisfactory.
No, I didn't say it's not satisfactory. I'm saying it's inadequately rationalized. So the explanation is, to me, is not adequate. They should have gone beyond what they said, so that it is clear to every person on the street.
Councillor Malisa, don't you think then this creates a loophole or creates a gap for myself or Darius to go to court to seek interpretation?
I mean, the courts are open to everyone. It is your right as a citizen to approach the courts. Okay, that's one thing people should get very clearly. Every person in this country, especially the Constitutional Court, because the Constitutional Court, they call it the People's Court, because the Constitution is a document for the people. So, if you feel that the Constitution, there's something that is wrong or something has happened which violates the Constitution, you can go to the court. Article 128, you can approach them with whatever question you have, and they have to answer that question. So if you approach them and you have noticed a lacuna in their judgment or whatever, one, you cannot appeal a judgment of the court of the Constitutional Court. Let me make that very clear. It's not appealable, right? But if you raise a new question and you want to ask them a question, you can do that. You can approach them, ask them the question, and they have to answer.
What sort of lacuna do you see in this judgment, or any?
Besides what Dr. Kaaba alluded to say, the Constitutional Court could have cleared the mud a bit to say what happens to the 2021 term. Because if someone is ineligible now, it means even in 2021 he was ineligible, right? So maybe in trying to navigate that, the same court had said he was eligible, albeit erroneously so, as they have admitted, then they could have, like you said, explained to say, okay, he wasn't eligible then, but because we said he was eligible, then now to save the country from all the expenses and we're going to do this, and that would have put everything clear. But besides that, I'm not seeing any lacuna, as you say, in this judgment that I can take back to them and say, because in terms of the reasons why they say he is not eligible, I think they explained, they exhausted that, they explained. Maybe what could be lacking is the reconciliation between their position then and their position now. Maybe that's a bit shaky, but in terms of the technicality or the, what can I say, the soundness of how they interpreted this section 2, this section 7, they say Article 35, Article 106, the retrospective application of the law, I think on that one they laid it bare. They did what could be done.
It was a bench of 7 Constitutional Court judges. Obviously, what others expected was that there was going to be a dissenting judgment. Did you expect a dissenting judgment, or are you shocked that there was no dissenting judgment? Let me begin with you, Dr. Kaaba.
Yeah, thanks. Actually, I wasn't sure which direction the court would go on this one, so I was open to any possibility, because largely looking at how the Constitutional Court has handled such matters, so I approached the issue with an open mind. But owing to the fact that I think some of the judges today had sat in previous decisions, that raised the possibility that they might wish to have to defended their former positions. But that didn't happen, so the explanation then has to come from the court and not ourselves.
Is it unusual and regular that the same judges that litigated a matter raised interpretation, and now again they're relitigating it? They have a different position, and none of those that agreed with that majority judgment, doesn't agree with this new position. Councillor Malisa.
It has happened before. In this same case, if you look at the Dan Pule judgment, Dan Pule was a unanimous decision of the court. Everyone agreed. If you come to Legal Resources Foundation, Judge President Mehluli dissented. But she was part of the decision in the Dan Pule case. So it has happened before. Now, in terms of if I expected a dissenting judgment, I also, when I was sitting here, I did not know which way the court was going to swing. And if you remember what I said it's either they are going to say we stick to our decision, or they are going to say we want to correct our decision, right? One of two. And they chose the latter. So I wasn't sure which direction they were going to go. I wasn't sure, to be honest. I didn't know what they were going to decide.
What would you broadly say is the potential implication of this landmark decision that the court has made to vacate its decision in the growth of our law?
Like I said, it's not the first time a court vacates its decision.
The Constitutional Court, at least. Okay,
the Constitutional Court is a new court. It's the first time it has happened. The Constitutional Court was set up almost 10 years ago. It's almost reaching 10 years. It's 8 years now.
8 years, 2016.
8 years, 2016, yeah, 8 years. Okay, so, look, a court vacating its decision was bound to happen. Okay, it was going to happen at some point. Maybe the argument would be it's too early or what, I don't know about the time frames. But courts departing from precedent. It happens all over the world. That's why the Constitutional Court today took us on a trip to other countries so that to show us that it is not only in this country where a court can depart from its precedent. So I'm saying that it was going to happen. So what implication does it have on the jurisprudence? I'm sure, let's be honest here, there has been a lot of mistrust in terms of the Constitutional Court. I think from day one, the Constitutional Court has come out under serious criticism. I think it's the court that is most attacked in this country.
Yep.
Ever since it was set up from 2016, I think they haven't had any breathing space. Every other time their decisions are put under the microscope. And I think maybe that's because of the nature of the court and the nature of the cases that it deals with, because most of the time they have far-reaching political consequences, like what has happened here. It's not like any other court. So yes, there has been that mistrust of the Constitutional Court. Starting from day one, there has been questions of competence, this. The decisions that they've made have come under criticism, they're not consistent, all these things are there. Right. Are they going to stop? I'm not sure. I'm not sure that the criticism of the Constitutional Court is going to stop after this judgment. I'm very sure that those in academics, like I said last time, that once a judgment is given, it becomes food for academics like Dr. Kaaba. They will have it for dinner. They will criticize even where the full stop is. So this judgment is going to be scrutinized by legal experts, not just in Zambia, but all over the world. And they're going to come up with a position. Right. As to the development of our jurisprudence, I mean, every judgment essentially has to, especially if it's coming from an apex court like the court of the Constitutional Court or the Supreme Court, by default, it should contribute to the development of jurisprudence, because those are certain, like it's the highest court in the country, and its decisions have got far-reaching consequences. So, as far as this decision is concerned, I really can't tell in the future whether it's good or bad, but what I can say is that it's good material for the academics. The academics can write.
Dr. Kaaba, politically this has put the judiciary under a microscope. I don't know legally if also the judiciary have been placed under a microscope.
Yeah, I think the nature of the case definitely, because the political cases naturally are polarizing, and in this context we have two large political parties ruling PND and PF. I think is still, in terms of representation in parliament, is still the main opposition. So naturally, the one camp will be happy, the other would not be happy. So from a political lens, I think the case is likely to continue on that path of the debate around polarization. But beyond that, and tagging into the question you raised about its contribution to the growth of jurisprudence. Departure from precedents, in my view, allows the possibility of growth of law as long as it's done for the right reasons, and it allows the courts to take into account new circumstances and new developments. But it also depends on the reasoning given, the justification given by the court. So if the justification given doesn't make sense, so simply departing from a precedent adds nothing. But if it is for good cause and the court adequately justifies its position, I think then that way you are contributing to the growth of jurisprudence. And in this case, I think there was a huge attempt to do a bit of comparative research, and in my view, did a good job in terms of putting comparative case law and authorities from other jurisdictions in terms of when an apex court would appropriately depart from precedent itself. It set itself, and that way I think the research helped to build their own case and to enrich our own jurisprudence. I think if the court continues on this path of doing good comparative research, that could continue to enrich jurisprudence. Unlike in some of the decisions of the same court, I think where they simply make decisions on gut feelings and simply reproduce copiously provisions in the Constitution without any clear analysis. And one thing I liked about this case is actually the courts paid more attention to careful analysis of the provisions, and there's very little in terms of reproduction of provisions and simply copy and paste of what was said by another court. I think from that perspective, I think it allowed the decision, yes.
Now, Dr. Kaaba, the Constitutional Court has made this, interpretation of the law regarding the eligibility of the former president Edgar Lungu, and it has reached a conclusion that he was not, eligible to contest future election. What message does this ruling send to political leaders about, adherence to constitutional limits?
Yes, so when you read the judgment, I think the court also tried to try to put the judgment in the context of constitutionalism in Africa in terms of limiting presidential terms. I think going back a bit, I think we come from a context where before the wind of change in the 1990s, where presidents stayed in office until either they died or they were removed by the military. So they could do whatever they wanted. Elections were not a threat to them because they manipulated the whole thing. So when there was a wind of change in the late 80s and 1990s, I think one of the targets for constitution makers was to limit the term of office for a president. This is because although we need presidents, but they are also the biggest danger to any country's democracy because they wield the greatest power which could be abused. So when you limit how long they stay in office, that is a control mechanism. And in this case, the court cited the AU framework, but also they cited the Oxford Handbook on Comparative Constitutional Law and indicated that their interpretation is in line with that desire to limit office for former presidents. So from this perspective of limiting how long someone stays in office, then you could say that contributes to constitutionalism, because if someone can't stay longer in the office, then that control mechanism helps to tame the presidents.
Councillor Malisa, another conversation that has been very important in our country has been that to the effect that there ought to be respect in terms of the three arms of government. I would like to get it from your perspective in emphasizing how important it is to ensure that there is independence of the three arms of government, both in their function and how they are seen to run.
Okay. So you are speaking to what in constitutionalism they call the separation of powers, the doctrine of the separation of powers. I agree that with the notion that there must be independence in terms of functionality and also in terms of composition of the three arms of government. This is a conversation that has been going on in Zambia, I think, for a long time now. If you look at the reports from the different commissions that were set up to review the constitution, especially the Mvunga Constitution and the technical committee, the thing that came out very clearly was the desire by Zambians to have the arms of government separate and have some semblance of independence. One of the issues that has come out consistently is on the issue of trying to separate the legislature from the executive. And the issues of ministers coming from outside parliament was raised in all the commissions. Surprisingly, it hasn't made its way into the constitution. And I think it would help in having that separation so that you have a proper check. Because right now it's very difficult for the legislature to check the executive because members of the almost all members of the cabinet are coming from the legislative chamber. And these are the same people who are supposed to check the executive. So how do they check themselves? Right. And then when you're talking about the judiciary, I think a lot of issues have been raised as to how judges are appointed. And my view on this is that right now, the law as it stands leaves a lot to be desired in terms of the functional and the operational independence of the judiciary. Because, one, the method of appointing judges is shrouded in mystery. It's not transparent, and it is not protected from executive overreach. Right? It's not, as it stands right now. So there is room for legal reform in that area, that we need to reform the law on how judges are appointed and also how judges are removed, right? Because it's all two sides of the same coin, right? If the process of appointing is not protected, definitely there is no safety there. And I'll emphasize, and I'll adopt what State Counsel Sango said, that we have to ensure that the process of appointing judges is top-notch, so that, one, we have deserving people being judges. And then, if you deserve an appointment, it's very easy for you to stake your independence, because you know that I deserve to be here. I don't owe anyone any favor. So, whatever rulings you're making. And also that protection should extend, if it's an open process where judges are appointed openly and it's open to the public and the public can see, even their removal equally should equally have that protection of being done in the open, so that people should know that, okay, these people were appointed openly. We saw they were scrutinized openly. Why are they being removed? Right. Okay. So also the involvement of Parliament, like I said, the separation between the legislature and the executive right now is somehow non-existent, I'm sorry to say. So you'll find that even the appointment of members of the judiciary, the moment the executive just says we want this person, no matter who opposes, they will still pass, because the people sitting in the legislative chamber are also part of the executive.
The executive. Dr. Brian Kaaba, there's been allegations to the effect that there's been strong interference, in the three arms of government, especially from the executive to these other two arms of government, the legislature as well as the judiciary. And obviously, as an academician and one that follows these things, you've seen the attacks that have come on the others call it unceremonial removal of the three constitutional court, judges. I'd like to get your opinion and your observation on the conversations around how others would allege that the executive has really interfered in the running of our judicial system, our judiciary in our country.
Yeah, thanks. I think the starting point is what my colleague Malisa has indicated. I think we still have structural challenges in terms of the way our institutions are positioned, because when you look at the judiciary, for example, salaries and conditions of service for judges are set by the president, although I think there's a recent decision by the Concord trying to push another direction. But in my view, I think even that position is not going to change anything, because the Remuneration Commission, it is in essence still an executive commission, so it changes really nothing. So the funding modality of the judiciary, I think, is still a bit problematic. The appointment system, the removal system is still problematic. So we still have those structural problems. That said, it doesn't mean that each individual judge gets a phone call from someone upstairs to decide. I think our main concern, I think, should be in trying to resolve those structural challenges, because those are the ones that create perceptions and also create the possibility of being co-opted by an executive. I think it would be in the good of the country if we were mobilized and lobbied for the reform of the law in those areas. that, in my view, cannot be done adequately outside the context of constitution reform. So that would still bring us back to the question of constitutional reform. On the question of the removal of judges, I think here we should not divorce the issue of independence of the judiciary from accountability for judges. So judges should be protected, yes, and to a great extent they shouldn't be easily removed from office. But at the same time, judges are human beings. They could make mistakes, and some mistakes could undermine their very office and the institution they're supposed to save. So if a judge is corrupt, takes a bribe, so we shouldn't just bury that and let it slide. I think the Constitution has mechanisms for removal of such judges. As to whether the constitutional requirements were met in these cases, I think that is for each one to come up with their own opinion.
How does the law interpret or define incompetence? I ask this because, to a layman, the judges that sat on the Daniel Pule case that erred at law have vacated from their decision and have made the correct decision. To some, that could be described as incompetence. And I want to find out, because what if Darius tomorrow goes before the Judicial Complaints Commission and complains that there are judges that are incompetent based off these facts?
They made a decision.
Yes, they erred.
The former president was eligible to contest.
I'd like to get your thoughts on someone that would think, like that, Councillor Malisa.
Well, that will be a question for the JCC itself to decide whether it's incompetence or not. If Darius wants to go there, the Constitution allows. He can go and he can present his case, and the JCC will decide whether there's merit in the case. Also, we also have the courts for that. The courts can be approached. Like I said, anyone can approach the courts, and the courts can be approached, and the courts will make a decision on whether the allegations have been substantiated or not.
Another argument that has been raised, Dr. Kaaba, is the fact that the 2016 Constitution is not sufficient for us to go, with it in the next election in 2026. One of the people that feels like that is our Republican President, Dr. Hakainde Hichilema. He raised concerns around some of the lacunas, in our Constitution. How much do you think is a need for us to work on our Constitution before the 2026 elections? And do you feel the 2016 Constitution, amended Constitution in its form, is sufficient, for us to go with in the next election?
Yeah, for me, I think the question is bigger than just the 2026 election. I think we should look at our democratic aspirations as a people and look at the quality of our institutions now and where we want to take the country. And if we decide that we're not happy with current context of our institutions and we want a better country, then it is within our power to move in that direction of changing the Constitution. My humble opinion is that the current constitutional framework is completely inadequate, because I think when we moved from the one-party rule, what essentially changed is simply liberalization of politics. There was no re-engineering of institutions, so institutions are still tailored to serve the executive and not the people. So in my view, to change that would need to change the whole constitutional orientation. So we still need to revisit the constitutional question. But coming to the specific issue of that question of the Constitution in relation to dealing with electoral issues, I think we have problematic clauses. One of them is the clause dealing with what happens when a candidate withdraws or resigns. So prior to the last election, I think the court indicated that even an independent candidate, if that candidate withdraws from the race, then the nomination is cancelled and you have to hold fresh nominations, and the election consequently could be affected. But then recently they revised that position. If it's a mere independent candidate, then the election is not affected. But then the election could still be affected if if a candidate who belongs to a party withdraws. or resigns from the party, or decides for whatever reasons not to proceed with the election. So that potentially means that you could have a disrupted election going forward, and the cost, especially if it happened at the presidential level, could be massive. But not just the cost, I think the capacity for instability and national security issues, I think the potential to cause a security challenge to the country is massive, and that is, I think, what should be looked at. Whether that should be done now, I think it's a difficult challenge, because when you change laws too close to an election, I think there's always suspicion that you're doing it in order to survive as a ruling party. And that is where I think I have issues with the current government, because these problems were known early. They were raised in almost all the reports of election observers as potential landmines going forward. But for some reason, the government decided to do nothing and just woke up now that the country is headed to the pause. So I don't understand that.
How much of a need is this? We heard the president say that we might end up with an individual being in the position of presidency even for more than 15 years because of such lacunas. Some legal experts blasted at the president. Some called him a dictator and all those things. But I would like to get to pick your mind on how urgent it is for us to amend our constitution, especially provisions that border on electoral reforms.
Okay, I'll pick on where Dr. Kaaba left. I think it will be dangerous to amend the constitution with the sole purpose or with just elections in mind. That defeats the whole purpose of constitutional amendment or constitutional reform. Let me call it constitutional reform. So, the constitution belongs to the Zambian people. It is the most important statute in this country, and it has to be taken seriously. And we can't be tampering with the constitution just because we have elections coming. The danger with that is that what happened in 2016, where we are now, we're talking about all the problems we have in the constitution, is because of what happened in 2016, because we tied constitutional reforms, especially to do with the Bill of Rights, to a political event. Elections are divisive in nature. They are competition, right? They're political contest, they're joust. And it's very difficult to achieve consensus over an important document like the Constitution when you are staring at an election. The most ideal time to carry out constitutional reform, like Dr. Kaaba says, the government has taken too long. Because from day one, they knew these problems were there. Yep. It was going to be easier to carry out these reforms outside the electoral cycle. And then, at that moment, it looks genuine. There's some legitimacy to it, because then there's no competition on political grounds. People will come together genuinely. What are our problems? How do we sort them out? And people will garner that consensus. Now, at this point, I think it's too late now to want to start reforming the constitution now, before the 2016 elections, because we're going to have a dangerous situation like what happened in 2016, where the constitution is put to a referendum and then it fails, just because the politicians are going to hijack and turn it into a political contest like what happened in 2016. So I would say that, yes, it is urgent for us to attend to our structural problems, our institutional problems, through a constitutional reform. But we have to be very careful how we do that constitutional reform, so that we don't end up in the vicious cycle that we've been going through all over and all over and all over again. So if the current government can wait for the election to pass, and whichever government comes in, if it's still them, the problem still remains.
We'll start with you, Councillor Malisa. Your concluding remarks, generally, the eligibility and the issues that we've discussed.
Well, look, what I'll say is that in court, we are lawyers here, in court, one of my colleagues says it's not like football, where a draw is a possible outcome. When you're dealing with court matters, there are no draws. There's a winner and there's a loser. So, at the end of the day, the country should win. okay? Whatever decisions are made by our courts should have the country in mind, and they should be aimed at growing the jurisprudence of the country, and more importantly, growing the democratic dispensation of the country that we aspire to. So the courts are a key institution in a democratic dispensation like ours. So going forward, it is important that we strengthen our institutions, number one, and also we need to respect the decisions of the courts, whether we are happy with them or we are not. Okay, we can't all be winners. Some people were smiling in 2021 when certain decisions were made, others were crying. Today, others are crying, others are smiling. That is the nature of litigation. Okay? Nothing out of the ordinary has happened. Someone lost a case, somebody won. And it's going to happen in future. But what is important is that people should remain with a level head. People should not go out of their depth because they are not happy with the judicial decision. These things happen. So let people remain calm. Let's respect our institutions. Let's try and build those institutions and try to instill public confidence in those institutions.
Dr. Obrien?
Yeah, thanks. Just to start from where I had ended, I think the nature of going to court is that you come up with a winner and a loser, and therefore the outcome is going to be celebrated by one camp, and another camp is going to treat it with contempt. But the issue for me, I think, is that the case also exposes, I think, the danger of the current structure of our politics, where presidential elections are a zero-sum game. So if you lose an election, you lose everything. And so for you to have a stake or control, it basically means you have to win. And once you lose, then everything goes. And that is where I think we need to serious institutional reform of our system, electoral system, political system, and also institutions. And if this is not remedied, it will continue to polarize the country and polarize the people, because those who support the former president will not be happy, including the electoral geographical areas where they have a strong following. And that is not good for the country. And I think this is where we need to sit down together as a country to reform our constitutional order so that we don't have a system of winners and losers. I think we need a system where, regardless of the outcome of an election, all the citizens feel they have a stake in the well-being of the state and the government, and they have a continued forum for participation in government. And we need to explore certain mechanisms such as devolved forms of government, where even if you lose the presidency, at least you have control at certain level of government, especially at subnational levels. So thanks for inviting me, and I hope the debate continues. I think the debate is good for the country. If people speak freely on such issues of public importance, then our democracy is growing. Thank you.
Dr. Obrien, Kaaba, thank you so much for making time. Council Mehluli, Malisa, thank you so much again for making time to be with us tonight. As we were wrapping up on the eligibility of President Lungu to contest the 2021 elections and to contest the future elections. We've been building up from last week Friday until today, the judgment day. I hope we've been very helpful in trying to break down some of the technicalities in the court judgments that were already determined and the new judgment that has come. On behalf of the entire production crew, thank you so much for watching. My name is Andrew Mwansa.
Thank you. Thank you.
Thank you.